In part one of our series, we introduced you to Montana Code Annotated 25-9-411, aka the cap. It says a Montanan cannot earn more than $250,000 for their pain and suffering in a medical malpractice case, even one that results in permanent severe damage or even death. Don't be surprised if you didn't know about this law. Most people don't, including the jurors who oversee these cases.
I was one of the lucky 13.
TJ Reifer won't soon forget his week at the Cascade County Courthouse last year.
I got the luck of the draw to be the foreman.
The case, Zahara versus Advanced Neurology Specialists. Great Falls resident Joey Zahara claimed that Dr. William Henning caused irreparable harm by not showing up to treat him after Zahara had suffered a stroke, even though Henning was the on-call physician.
The first half of the day we were discussing the liability portion of it. Did we feel that he was liable or not?
The jury first concluded that Henning was guilty of malpractice. Now they had to decide what that was worth in 6 different categories. Things like pain and suffering and loss of established course of life.
And they kind of wanted a dollar figure on each of those.
On September 15, 2022, the jury awarded Zahara a total of $6 million. Reifer and his 11 new friends had done their job. But 13 days later, the defense filed a motion to lower that $6 million to the constitutionally mandated maximum of $250,000, the cap in Montana.
First time I ever heard of anything about the cap was when you mentioned it to me. So I had no idea that there was any such thing.
That's because he's not allowed to know. And that's one of several problems many have with the law. You feel like it was a waste of time?
Honestly, a little bit.
The cap itself is a pox on our Constitution. It truly is.
Billings attorney Steve Harmon spent 20 years as a civil defendant before changing sides, largely because of laws like the cap. Most know any trial in the United States is supposed to be determined by a jury of your peers, but the cap directly invalidates the jury's decision.
You're no longer the conscience of the community. It's been usurped by the legislature.
The cap was passed by the 1995 Montana legislature to make Montana a more attractive place for doctors by arguing their medical malpractice insurance premiums would go down. But that hasn't happened.
When the insurance industry advocated for this law, there was testimony to the effect that we will see premiums lower within 5 to 7 years. Never has happened. Never has happened.
What has happened is those insurance companies have started offering less and less money in settlements because they know they have such little risk. From 2012 to 2018, 2,830 medical malpractice claims were filed in Montana. 20 of them, or 0.7%, went to trial.
They say the most you could ever recover is $250,000. And so we're only going to offer half of that now.
Cap opponents point to Article 2, Section 16 of Montana's Constitution. No person shall be deprived of full legal redress for injury occurred for which another person may be liable. Pay attention to the phrase, full legal redress. That means the full amount handed down, which by definition, they argue, makes the cap unconstitutional. But that's nothing new.
Lots of laws are passed that are unconstitutional, and the courts get to review those to see if they protect Montanans.
The problem is, in the nearly 30 years the cap has existed, it's never been challenged at the Supreme Court because medical insurance companies don't want it to be.
If there's a $6 million verdict, the insurance company will come in and pay most of it, perhaps, in settlement to protect the cap. If you want to challenge the cap, you risk the Montana Supreme Court upholding the $250,000 cap. So it's a real ethical dilemma.
Next time, we'll meet a Miles City woman who 2 years ago was faced with that exact dilemma. Casey Conlon for MTN News.